Good afternoon, everyone. My name is Lluc Cerda. I'm the managing associate of our Calgary office of Samfiru Tumarkin Employment Lawyers. We're coming to you today live on Facebook and YouTube to discuss your employment rights. Feel free to write your questions in the chat. I'll be getting to them and addressing them as they come in. We're together for half an hour, so get those questions in quickly so we can discuss the hot topics that you have on your mind concerning your employment rights. But as we wait for some questions to come in, I wanted to talk to you about a recent case that we got here in Alberta. Interesting case. To understand it, you need to know a little bit about the intricacies of severance. So a lot of people aren't aware that your severance can be provided to you through what's called a working notice. So you hear a lot that you can get up to 24 months of severance. Essentially, what that means is that the employer has to tell you 24 months in advance that you're going to be let go. And if the employer can't do that, then they pay you out a cash value of 24 months. But if they can do that, they can very well just say, well, in 2 years, your job is going to end. And then by then, I won't owe you any severance because you'll have 2 years to figure out what you want to do. So an interesting case came across the Court of Queen's Bench here in Alberta where someone had been given, I think it was 14 months of working notice. But what happens is at the end of the 14 months, he wasn't terminated. He stayed on for a little while after that. And so the question before the judge was, well, does that 14 months actually count if you stay longer than the 14 months? Interestingly, it didn't count. And it's something I've been saying all along is, if you stay on after the working notice is over, the clock resets. And that's what happened in this case. So this gentleman who the employer thought had been provided with 14 months of severance, the court found that he had not been provided with any severance legally and was owed 24 further months of severance, which was ordered to be paid. So if ever you're being offered working notice by your employer, important to reach out to us. It's got certain special rules, but there's ways around working notice as well. So anytime you get working notice or a termination letter and you want to know what your employment rights are, important that you contact us before you sign any documents. And if ever the employer is saying, no, you need to sign right away, that's not true. There's no legal requirement that you sign right away. Ask for an extension. Tell them it's because you want to get your legal rights and information about your legal rights from a lawyer, and contact us. Very important to do that. Step number one. All right, we have a question from Lou on Facebook. How long does it take for a lawyer to complete severance negotiations? So generally, it's very quick. We're talking about 1 to 3 months generally. The thing to know is that it really kind of depends, right? So 99% of our cases will settle prior to a trial, but you can imagine they don't all settle at the same period, all right? Some of them will settle very early prior to a lawsuit. Others will settle on the eve of trial. And of course, that's never ideal, but it does sometimes happen. But I would tell you the vast majority of cases will settle in that first 3 months or within another 3 to 4 months after the start of litigation. So it is a quick process, absolutely. I've got a question here from Jennifer Hammond. Forced to sign a confidentiality agreement that makes what they do to cover their crimes. I'm not exactly sure what you're referring to. There's kind of two different times where you might be presented with a confidentiality agreement. One would be when you sign during your employment, a confidentiality agreement that you won't reveal trade secrets or confidential business information or things like that. You want to look into that, make sure that it's not also combined with, a non-solicitation or a non-competition clause, and make sure you're not signing away any rights that you have as, a patent owner or an inventor or anything like that. But otherwise, the employers will sometimes ask you to sign a confidentiality agreement. And then also when you settle your matter after you've been terminated, almost all cases, you're going to have to sign release, which is a document that states that this puts an end to any disputes that you have. And generally, one of the conditions is also that you keep the settlement confidential, so that the settlements stay confidential. So that's been in the news a lot. We've heard about it with certain, celebrities that were having victims of sexual assault or sexual harassment settle their claims, but then sign confidentiality agreements, and it has allowed these perpetrators to continue to perpetrate. So that's definitely a hot topic now in employment law and in contract law in general, and in litigation. Is when is it inappropriate to sign a confidentiality agreement? But absent those considerations, which are generally not present in the vast majority of employment contexts, the employer is really trying to get to keep the settlement confidential, so you don't share it with other workers that you worked with or other people, so that they go after the employer for that same amount. It's a standard term. It happens in just about every release that I see. So, I mean, here you were mentioning crimes, so that's maybe outside of what we usually see, Jennifer. But if you are concerned that you're being forced to sign away or to sign a promise that you'll keep silent, definitely important to speak to a lawyer before you sign it. Once you've signed it, it becomes a lot more complicated. But before you sign, definitely speak to one of us. Reach out to us. We're at employmentlawyers.ca. That's employmentlawyers.ca. We're happy to help and see how we can help you out. Employment lawyer, I always get it wrong. Employment lawyer in the singular. Sorry about that. JC 2004X asks, in BC, when a job listing states that it is federally regulated, does that mean vaccination is required? I have not heard of a mandate for the logistics industry. So just because you're federally regulated doesn't mean that there's a requirement that you be vaccinated. All right. So certain sectors of the federal government have a vaccine mandate, and certain sectors of the transportation, the transportation sector, also have vaccine mandates. As you've heard from the truckers, there was a requirement that they be vaccinated. Now, that doesn't necessarily mean that everyone in the logistics company, you're in, is required to be vaccinated. That's not the case. Banks are not necessarily required to be vaccinated by the government or anything like that. So generally, right now, it's the armed forces, the federal government. If you're in, airlines or rails, or if you're a trucker, you have to be vaccinated. But it's not sector wide on all federally regulated companies. JCX follows up saying, JC 2004X follows up saying it was FedEx or UPS warehouse. That's a good question. So I think FedEx generally would fall under the federal government mandate, yes. And so that's being imposed on by the federal government, not necessarily by FedEx or UPS. Because they're in the transportation business. Yeah, if you're basically just a shipper, but you don't really get involved with the trucks or the trains or anything like that, then you might be okay. But if you're actually also moving the parcels, I think you would be covered by the federal mandate. Jennifer Hammond follows up with some comments. So it depends if you're in a union. I think this is referring, Jennifer, to your confidentiality agreement and whether the union is in the back pocket of management. Oh, I see where you're saying. Okay, so you were asked to sign a confidentiality agreement following a workplace investigation. So workplace investigations will usually, there's something that happened at work and the employer wants to investigate it. So they'll ask people that were involved, the complainant, the respondent, and maybe some witnesses to not testify, but to come and give their version of events to an investigator. And there will usually be a confidentiality agreement that will be signed at that point. What's important to realize about that, though, if you then decide, say you're the complainant, Jennifer, and you say, well, there's been a wrongdoing at work, and I think that I'm owed severance because I've been bullied at work, and now it's a constructive dismissal. Even though you signed a confidentiality agreement, it doesn't prevent you from suing. And because it doesn't prevent you from suing, it doesn't prevent you from saying what happened in court. or to your lawyer, all right, and have your lawyer say it in court either. Both of those things are. It's not the same kind of gag order that you see in releases that I was talking about earlier. They're essentially trying with the confidentiality agreement not to kind of poison the well at work, in the sense that you go and tell all the other witnesses what to say and what they'll be asked and all of that. So it is kind of standard procedure with investigations. In the unionized context, I don't know exactly how it would work. In the non-unionized context, it doesn't prevent you from seeing a lawyer either before or after you're called to the investigation. And the confidentiality really is to not discuss it with other people that are involved in the investigation, just not to compromise their testimony. It doesn't mean that you can't pursue it in court or anything like that. Andy McKinnon asks, can my employer enforce a non-compete clause? My current employment agreement has a very extensive non-compete, and it would pretty much require me to work in a different province for my industry. Well, you've basically outlined the issue with non-compete clauses right there, Andy. And the issue is that they can force you to leave your province, can force you to basically give up on the industry you've been working on for extended periods of time. Because of this, non-compete clauses in the eyes of the law are presumptively unenforceable. That's what that essentially means, is that it's up to the employer to prove that that clause is enforceable. And what the employer has to show is that it minimally impacts you. All right. So it minimally impacts you in terms of geography, in terms of duration, and in terms of job prospects. So look at your clause. It's hard to give you good information in the abstract, but for instance, I've had clients that basically, you work for an ice cream shop, for instance, and it says that you can't work for any ice cream shop in the same province as the one you work in for 5 years after your termination or after you leave. Well, that is completely overbroad, because it's not even clear that an ice cream shop just on the other side of the city would be actually in competition with the ice cream shop where you worked. So what happens? You get an ice cream shop, a job with an ice cream shop down the street. So this one is clearly in competition. But a judge is not going to ask himself, well, is what you're doing in breach of the clause, but is the clause overbroad? If it would have prevented you from working in any ice cream shop in the province, well, it's overbroad. So it's not going to be enforced. So it doesn't really matter whether you take the job down the street or across town or in another province. It's overbroad. Also, 5 years is way too long to keep you on the sidelines from pursuing your career in ice cream sales, for instance. So definitely a lot of ways to attack a non-competition clause. Also, there's quite a strong argument to make that if you're actually terminated from your job instead of resigning from your job, then any non-compete clause is not enforceable anyways, because it's not that you wanted to leave, is that you were pushed out, and now the employer can't use that to prevent you from looking for a new job. Right, so non-compete clauses are presumptively unenforceable. All right, so the courts are going to presume that they are not valid. So you want to have us look at them with you to ensure that there are strong arguments in favor of you not abiding by the non-compete clause. All right, so definitely get in touch with us. We're at employmentlawyer.ca. Reach out, have a consultation with us. We'll take a look at the clause, take a look at all the fine print. That's what we're here for. We're lawyers, and we'll let you know what that means in layman's terms for you. So I have some additional comments here from Jennifer Hammond. I think I answered your question, Jennifer. If there's still anything you're not sure of, please just add it to the chat, and I will get to that in due time, just to make sure I have answered your question there. Best Steve Yet asked, great name, Best Steve yet asks, I was hauled into a workplace investigation with 45 minutes notice, was not presented with who my accuser was or the details of the complaint. Any recourse. Was found not guilty. Okay. So, I mean, you probably would have more recourse if you were found guilty, actually, Steve. Yeah, essentially, I'm not a huge fan of that method, of the method of saying, well, come in here and explain your actions. You have no idea what's going on. Generally, my recommendation is try to get at least 2 or 3 days of notice and try to find out generally what they want to talk about. They're not going to give you every question that they're going to ask you, but they can generally tell you, is this related to some time theft? Is this related to bullying? Is this related to a dispute you had with a coworker? You don't want to walk in completely blind. The problem when you walk in completely blind is that you're trying to remember as you're answering the questions. And the first thing that happens when you walk out of there is like, oh no, that's wrong. What happens though, something to remember, if you do walk out of there and you realize, oh no, what I was saying was wrong. Actually, what really happened is this, send an email, correct your answer. You're always allowed to do that. All right. You can correct your answer saying, I had it wrong. You put me on the spot. What I said was A, but what I remember clearly happened now is B, and use that. And if you have any follow-up questions, let's talk about that. But generally, at the very minimum, if you go into an investigation, it's important that they tell you at the investigation, at least, what it's about and who's accusing you. Absolutely, absolutely. If you walk into a workplace investigation and they say someone saw you not clock out on your break, and so we're investigating you for time theft, important that you ask them, well, who did that? Who said that? And if they say we're keeping it confidential, that's not good. All right. So in a workplace investigation, it's important that you have the details of who, what, where, and why, and when, rather. So, for instance, if they're saying that you didn't clock out when you went to lunch, and therefore were overpaid by an hour, you want to know, well, who saw this? On what day did it happen? At what time did it happen? You don't want, and when did it show up on my pay stub, for instance? Because you don't want to say, well, it might have happened at some point in the past that I forgot to clock out, but that was an innocent mistake. You're not there to talk about everything that's ever happened in your working career at this workplace. You're there to talk about the accusation, right? So you need to know what day it happened at a minimum to be able to address it intelligibly. If they tell you, we're not going to tell you what day it happened, well, how are you supposed to answer? You have no idea, right? So don't even answer the question. It makes no sense. And if they don't tell you who saw you do it, then that doesn't help at all either, because you might be able to provide some information as to why this person has it out for you or something like that. So definitely you want to get the details of what you're being accused of if you're going into an investigation. So now, I'm sorry to hear this, Best Steve, but it seems that you're off work for mental health leave as a result of this investigation. You're in Alberta. So I'm in Alberta as well. I deal with Alberta employment law, so not a problem there. So I wasn't aware of this piece about your stress leave, Steve. It could be that there's more to it than I first realized. I think it's important that you contact us to give us a bit more detail of what you were accused of and how that led to your stress leave, or were there any other factors that contributed to your stress leave at work that you can inform us of. Sometimes when you're part of a poisoned work environment, that results in you going on stress leave. Part of being in a poisoned work environment can sometimes be a disingenuous or vindictive investigation. And of course, if that pushes you over the edge and you have to take a stress leave after that, that could amount to constructive dismissal. Absolutely. I'm kind of speculating. We'd have to get more information, but that's definitely something that you want to look into. And when you claim constructive dismissal, essentially the major component of what you're going after is your severance package. Now, remember, your severance package can be up to 2 years of severance. So it can be quite a lot of money for most people. So I suggest if you want to find out how much severance you might be entitled to, visit our website at pocketemploymentlawyer.ca. We have an easy 4-question quiz that'll give you an estimate of what your severance entitlements will be. So if you want to get an idea of how much severance we're talking about in terms of months or in terms of dollars, take a look at pocketemploymentlawyer.ca. It's free of charge, no obligation. You put that in anonymously and you get the information that you're looking for. Now, JC 2004X continues. It was just for loading trucks. So JC 2004X was referring to whether a FedEx or a UPS warehouse would be governed by the federal mandate. I think it is JC 2004X. It's not just the trucks themselves, but the warehouses where they're loaded and unloaded. I will have to check that. I'll be frank with you. I don't have that right at the tip of my tongue. I know that transportation, so truckers, have to be vaccinated. Whether that extends to warehouses, that's a good question. I'm going to look into that, and I'm going to pass that on to tomorrow's host. We do this employment law show every day, and I'm going to pass that on to tomorrow's host so that he or she can let you know if you're able to tune in tomorrow, JC 2004X, or I'm back at this day and time in 2 weeks' time, and I'll remember you by then, and I'll give you the answer at that time. But if you want the answer tomorrow, tune in. There's also a website or an email address where you can send your question. Tell them that I asked you to write to us at help@employmentlawyers.ca. JC 2004X. If you want that answer either today or tomorrow, you can send an email. They'll flip that to me and I'll get back to you. I'll just have to look into the regulation real quick. Dan Johnston asks, I work for a federally regulated company. Trudeau promised to introduce a law saying that all federally regulated employees must be vaccinated, but he hasn't done that yet. Unifor in Ontario lost to Coca-Cola. IBEW lost to BC Hydro last week. What does this mean now for federally regulated employees? I've been put on leave without pay since February 1st to be terminated on May 1st. And I see I skipped over one of your questions, Dan. You also wrote, again, Unifor versus Coca-Cola, IBEW versus BC Hydro. Those were cases where they lost. I'm going to get to that in a second. How is this possible when there isn't actually a law to allow this? What does this mean for federally regulated businesses that also don't have a law? So essentially what you're referring to are some union grievances, all right? So union grievances move a lot quicker than the court system. That's the one thing that's undeniable. So the unions in these cases grieve the vaccine policy of the employer, stating that they were unreasonable. And when a policy is unreasonable in the union context, it can't be enforced, essentially. So there's been a few of these grievances now since probably, I would say, the first one I think came out in November or December. So there's been a few. These two, they were held to be reasonable. I know that Unifor versus Coca-Cola really is a lot different than one that we had. I think it was Ontario Hydro 1. Also had a union grievance on the vaccine policy. It seemed to be going the other way. They found it was unreasonable. So, Dan, I don't know if you're in a unionized or non-unionized context. I can tell you that union grievances don't really translate well into wrongful dismissal lawsuits in court, all right? So, and these union grievances, what's important to remember is they're not termination grievances, they're policy grievances. So the employer is just or the union is just asking the arbitrator to decide whether the policy is reasonable. A policy can be reasonable, but a termination may not be reasonable even if it follows the policy. So something to keep in mind there. But yeah, these grievances are being settled even in the absence of a mandate. I can tell you the BC one. Well, there's been a new BC one. It wasn't BC Hydro. There's been a new BC one where there was a mandate. All right, and that dealt with the termination. Here, the ones you're referencing don't deal with suspensions. Don't deal with termination. All they're asking is it reasonable. After that, you can have that's a policy grievance. Then you can have a termination grievance to decide whether the employer had just cause to terminate. Because in the unionized context, you can't be terminated without cause. You either have to have cause or you can't be terminated. Your job is secure unless it's a layoff. All right. So there are certain important kind of conceptual differences between a union grievance and a wrongful dismissal lawsuit for people that are not unionized. So it would be helpful to me, Dan, if you can just write in the chat whether you're unionized or not. Maybe I can better direct my answer to you. Jason Flick, thanks us for the video. Jason, thanks for tuning in. It's great to have so many people with questions. And curiosity about your employment rights. I think it's important that people get the information, the right information, right from the source, right from a lawyer. There's a lot of speculation out there, both on the employer and employee sides. And if you have the right information, as they say, that's half the battle. Andy McKinnon asks, are you entitled to all the details in a workplace investigation? What if the person reporting wants to remain anonymous? I think you can have an anonymous workplace investigation. For instance, if you make a complaint to the Ministry of Labor, you can do that on an anonymous basis. So, for instance, I had a client that wanted to do this. They wanted to make a complaint, a work health and safety complaint to the Ministry of Labor, and the Ministry of Labor asks you, do you want to do it anonymously or do you want to do it with your name attached? And what we were claiming was reprisal. So we were claiming that this person had tried to enforce their right to work in a safe work environment and had been terminated because she had tried to enforce her rights. So if she had done it anonymously, then all the Ministry of Labor could do was check if they had an anti-reprisal policy, which is required. That's all they could do. And if they did have an anti-reprisal policy, that was the end of it. If she gave her name, then they would check if there was an anti-reprisal policy, and then they would check if they had followed the policy and not reprised against the employee. Okay? So big difference on how far the investigation goes when it's anonymous. So if I don't think you can have an investigation that says this person is bullying me, and then you pull the person in, you pull Jim in, you say, Jim, you've been bullying people. What do you have to say about that? And Jim asks, who have I been bullying? And they can't, well, I can't say, that's anonymous. Like, what exactly are you accused of doing, to whom and when and where, right? I mean, how can you provide an intelligent answer to any of their questions? Do you bully people in general? It's not an answerable question. So it's kind of a pointless investigation by that point. And you can, Jim is totally free to say, I have no idea what you're talking about. I'm not going to speculate on what I couldn't have done. If you have details, bring them to me, and then I can answer your specific questions. Lawyers will always tell you, when I'm starting a lawsuit and I'm preparing the claim for my client, I want dates, I want times, I want who was there, I want judges, investigators, lawyers, we all love dates, we all love times, we all love locations, we all love verbatim, what exactly was said. We all love that, because then you can take that to the witness and say, on March 24th, while Steve was with you, you said verbatim, I'm going to bully you now, for instance. What do you have to say about that? It leaves no room to interpretation, right? So that's perfect. Anything vague, like Jim says that you were mean to him. How do you even respond to that? You can't. You don't know whether Jim misconstrued, whether you were actually mean, whether your words were taken out of context. You don't even know what you said or when you said it. You can't answer. But to get back to your question, Andy, sorry, I went on a bit of a tangent there. You're entitled to some details. you're entitled to enough details to make an intelligent answer, and you're in your right to demand them. Absolutely, you're in your right to demand them. What'll happen though is at the end of the investigation, there will be an investigation report, and there's like a complete investigation report, and then there's an executive summary. And generally, the complainant and the respondent in the investigation will only get the executive summary, and the decision makers in the company get the whole thing. And what the whole thing might have is not just your testimony, what you said to the investigator, but what the witnesses said, what the respondent said, in a lot of detail, right? And you won't get that. And generally, you're not allowed to it until quite far along in a lawsuit. Rocket asks, generally speaking, how long does an employer have to discipline an employee from the date of the infraction until they would be seen to have expected it? That's a good question, Dan. Rocket, sorry. So one thing to, I'll just rephrase your question slightly. After how much time after they know about it? So the infraction happens on March 1st. They find out about it on March 15th. So that's the relevant date in this case, all right? Because if they didn't know about it, they can't be expected to have condoned it or allowed it. But generally, depending on the seriousness of it, they should be moving relatively quickly. So what ends up happening, though, is they don't move quickly and they terminate you 5, 10, 15 years down the line for a cause, for some weird reason. And then they're bringing up things that you did 15 years ago. I've seen this happen. You think I'm joking. I've seen this happen. Client terminated for cause. They're bringing up stuff from 2007, 2015. You know, it's like, that's way too long ago. All right. So if you knew about this in 2007, you can't rely on it now in 2022 for your cause termination. You needed to do something about it well before that. So we're coming up to the end of our time. I just wanted to follow up with Dan. So Dan Johnson, you are in a union, Unifor. Okay. So Dan, I don't want to give you advice in the unionized context. We say this a lot on the show. It's really two different worlds, the union and the non-union context. What you need to do is contact your union rep and see what they're doing to move your matter forward. See if they'll represent you in a personnel grievance because you're being disciplined and because you're facing termination. It's a really different world. Whatever I tell you today for a non-unionized employee will not necessarily translate well into the unionized context. And I'll take one last question from Galaxy Cat. If you sue your company, can they terminate you with cause? I would say no. Okay, so it depends what you're suing your company for. So generally, one way where we sue an employer, even though we're still employed, is in a constructive dismissal claim. We might say, you reduced my salary by 50%, but I'm going to stay in the job while we try to figure this out while I'm suing you. And your employer is saying, we didn't terminate. We never terminated this guy. This guy still got a job. So, okay, so I'll stay in the job. And I'll sue you for the difference for my full salary. And then the employer gets the lawsuit and says, well, I'm not going to continue employing you. Well, you've already sued them for your severance. So if they terminate you, nothing really happens. If you sue your employer for, I don't know, you get hit by your employer's truck in the parking lot, and you're suing them because you broke your leg or whatever. It's a motor vehicle accident lawsuit. They terminate you for that, they're going to have a tough time showing that was just cause. Really tough time. So I'd have to see the exact scenario where this is arising, but generally my view of it is that it wouldn't amount to just cause. Suing your employer is not enough to be just cause. No. I'd have to see the context for sure, but I don't think it would be. All right, everyone. My name is Lluc Cerda. I'm the managing associate of our Calgary office here at Samfiru Tumarkin LLP. I was here taking your employment law questions today. We will be following up again tomorrow and Wednesday. And we will be happy to continue to take your questions. I think actually we are next time on Wednesday with the managing partner of the firm, Lyor Samfiru, will be answering your questions as well. Thanks to you all for tuning in, and we'll see you very soon.